Microphone okay? Everybody hear my ugly voice back there? Great. Welcome to day 4 of the 23rd Annual Popcorn Forum Symposium at North Idaho College here in Coeur d'Alene. My name is Mike Kennedy, and I'm honored and excited to be here today to introduce our speaker and launch the day's activities, which will include a response panel to this morning's talk from noon to 1:30 in the Student Union Bonner Room. Our speaker, Harvey Richman, will be there as well, and we invite you to attend. It should be a very interesting and informative presentation. If I may take a moment, I would like to bring to your attention the fact that because the sponsors of the symposium invited me to be here, allowing me free access to a microphone and an audience, we can all be sure that it must be April Fool's Day. And it is. Our speaker today is an attorney at law, practicing primarily in the areas of litigation and civil rights here in Coeur d'Alene. Harvey Richman was first admitted to the practice of law in Florida in 1964 and admitted in Idaho in 1983, where he has tried cases in the state and federal courts, as well as in the federal courts of Georgia and Alabama. He has also tried cases in the federal appellate courts, in the 1st, 5th, and 11th circuits. Richman is a strong advocate for the protection of individual rights under the United States and state constitutions, with a special constitutional interest in the protection of individual privacy. His address today will suggest that there are political movements afoot in the United States, and especially here in the Pacific Northwest, to enact state constitutional amendments and initiatives that would attack the right to privacy involving personal relationships. In order for the public to fully comprehend these movements and their goals, it is important to recognize their roots and what guides their agenda. Before our speaker speaks, we'd like to inform you that there is a microphone for questions, and he will be entertaining questions. The microphone is for the benefit of the other folks here, and as well as the video camera, so please speak directly into that when you ask your questions. With that in mind, please join me today in welcoming Harvey Richman.
Gentlemen, students, members of the faculty, thank you. I want you to know that I'm also a notary public, and that was omitted from the announcement. I want to share that with you. I will begin with some more formalized aspects of my speech to you this morning. I will then hopefully share with you some practical circumstances which have occurred here in the courts of Idaho and some of our sister states. And should there be any questions or arguments or debates, I hope I can hold my own on that, and I will be available to you. Privacy is one of those dear things which most of us presume is a constitutionally mandated right, along with life, liberty, and the pursuit of happiness. In point of fact, privacy is, in this sense, not anywhere referenced in the Constitution of the United States or in the Constitution of the state of Idaho, though it is mentioned in the Constitution in Washington and in California. It is rather that the right of privacy, as many other constitutionally based issues, is drawn from the language of the Constitution and the Bill of Rights as a result of interpretation and application. Privacy was first proposed as a right by a justice of the United States Supreme Court, Justice Brandeis, who, with Samuel Warren, wrote an article in a Harvard Law Review in 1890. He suggested that there existed a constitutional, logical, societal expedient reason for elevating the concept of privacy to a protected right under the United States Constitution. In later cases, for example, the now famous Roe versus Wade, which was a privacy case, it was not an abortion rights case. The U.S. Supreme Court spoke to the right of privacy being a penumbral right. That is, one of those rights which existed within the penumbra or the shadow of the more specifically enumerated rights under the Constitution and the Bill of Rights. Thus, we see how the Constitution, along with the Bill of Rights, by necessity, a dynamic, malleable document which has worked reasonably well over the past 200 plus years, we have to understand that the Constitution and the Bill of Rights both shaped public opinion, economic practice, and the politics of the United States. but it was also responsive to those forces, and those forces directed its future. The framers of those instruments were not such visionaries that they could have ever conceived that some of the aspects of what we now know the Constitution addresses was ever intended. For example, a Commerce Clause. It was never intended to apply to radio and television. Nonetheless, it does. Similarly, the combination of the First and the Fourth Amendments create for us a concept of privacy that suggests clearly that privacy in this country is now essentially a constitutionally guaranteed right. The debate then focuses on how broad is this right, where the right becomes a privilege, where the privilege ends. That is, how to balance the rights of the individual with the interests of society. We call that the common good. I suggest to you that those of us who do not study history are forced to relive it. Thus, today, we must be very sensitive to the development of imbalances which are these competing interests, the rights of the individuals, the interests of society. If we want to avoid the repercussions of these imbalances, we must be cautious. I direct your attention to that concept because there have been historically some judicially determined circumstances which, in a body no less august than the U.S. Supreme Court, have determined to be constitutionally solid, but which circumstances wreaked havoc on either the fabric of our free society or on individual rights. You're all aware of the historic case of Plessy versus Ferguson. The U.S. Supreme Court approved the concept of separate but equal. This allowed the government to promulgate discrimination against ethnic minorities to the grave and lasting detriment of our society, I should share with you. We are only now beginning to recover from the social, economic, and psychological damage done by that short-sightedness, and sometimes the violent resurrection of dignity which we have come to know as integration. There is, for example, the admission of Belva Lockwood, a woman, an attorney, not permitted to practice in the federal system. The internment of Japanese Americans during the 40s, and no less, that concept was approved by William O. Douglas, a true liberal justice of the Supreme Court, who expressed for the U.S. Supreme Court a fear of the overthrow of this country by some of its most devoted and patriotic citizens. These are just examples of how the dynamics of the Constitution and the Bill of Rights have worked to declare certain actions constitutionally supportable, which, with the passage of time, were re-examined, and in the context of issues which later became popular or current or acceptable or necessary, resulted in a reversal of those decisions and a granting of constitutionally protected rights where none earlier existed. The point is that constitutional rights are always in flux. They are responsive to changes in our society. There are three branches of government. The court can affect social change, but so can the president, so can the Congress, and so can the people. Sometimes it takes legislation to shock the court. Sometimes it takes the court to shock the legislature. And sometimes it takes the people to shock them all. In the matter of Lockwood, for example, this woman attorney was allowed to graduate from a law school, fully accredited, but she was not permitted to practice before the federal court system. The Supreme Court of the United States ruled she did not have the privilege to stand and argue. The reason? It had never been done before. Ergo, it would not be allowed now. And it was not until 1878 that the U.S. Congress passed special legislation to relieve certain legal disabilities of women, which opened the way to the rights of women to practice in the federal court system. There came a time when the privacy rights of women to be secure in their own bodies on issues of both contraception and childbirth were ultimately examined by the judiciary. And now, in the famous Roe versus Wade decision, it was established this time judicially, that the privacy rights of women on issues of sexual intimacy were theirs to control. Here is a textbook case of an attempt to balance the rights of the individual to privacy with the interests of society in protecting the life of the unborn and possibly a biologically viable child. You must understand, from the standpoint of the United States Supreme Court, there was no effort to counsel abortion as a means of birth control, or to lay the groundwork for federally sponsored abortions, or to determine when life begins. Rather, the court was primarily concerned with a woman's right to privacy, the right to her own sexual intimacy, where the government had no determinable or demonstrable justification for intruding. I do not mean to trivialize the difficult moral or philosophical considerations of the unborn, but I submit to you that as a matter of constitutional principle, the court would also invalidate any attempt by a government to limit access to birth control or to governmentally sanction the rhythm system as the only method of birth control. We have, of course, had some executive intrusions into the privacy principle. In Roe versus Wade, again, the Bush administration refused to use federal troops to defend access to abortion clinics, or applied the Byzantine rules of mentioning abortion in the context of family planning clinic advice. Rather bizarre, but it's perhaps historic. It now seems that with the new presidential administration, a receding from those restrictions will most surely occur. We see also the debate in Congress on the subject of gays in the military. We've heard the president's announced position on the matter, and I would suggest to you that in the most recent case on the subject in the United States District Court in California, Meinhold versus the United States Department of Defense, a federal court now recognized that the Department of the Defense cannot enforce a simple fiat of banning gays and lesbians in the military based merely on status. It must do so predicated on a policy that is rationally related to permissible goals and not permitted to travel solely on what they have historically done, that is, good military judgment. That simply won't fly. That case, of course, is subject to appeal. And now, for the first time, a United States district judge clearly ruled that gays and lesbians will not per se be banned from the military. To that extent, as long as those persons behave as ladies and gentlemen, they will be permitted to wear the uniform of our country. The judge went on to state that the Department of Defense's justifications for its policy in banning gays and lesbians from the military service was based on cultural myth and false stereotypes. That these justifications are baseless and similar to the reasons offered to keep the military racially segregated in the 40s. It is, again, history revisited. Coming up to the more current issues, we have lately pending in Idaho a proposition sought to be placed on the ballot which suggests that its purpose is the granting of special status to gays and lesbians. This matter is being proposed as an initiative to be placed on the ballot in the fall of 1994. The Idaho Attorney General, Larry Echohawk, who happens to be a Native American, has issued, as he is mandated to do, an opinion on that proposition and found in a well-reasoned, multi-page document that the proposition does not pass constitutional muster. It will, in his opinion, fail if addressed in the courts. There are parallel cases in other jurisdictions supporting his opinion. In Colorado, where a similar measure was passed, the trial judge delayed implementation of that statute because he found it to be facially, constitutionally infirm. All of this brings us to a more focused privacy issue, which is, though sensitive, of course, an appropriate issue for a matter of adult conversation. This matter is part of what this initiative is about. What is at stake here with this initiative? Can the state enter our homes and tell us how we as adults, in the privacy of our own castle, can behave, as long as that behavior does not impinge upon the rights of others? In some regard, the answer is yes. For example, they can tell us that we may not smoke marijuana, and they may one day tell us we may not smoke tobacco. They have historically told us that we may not drink alcohol. You do remember the 18th Amendment. But can they tell us how we may behave in our interpersonal relationships as consenting adults? The answer is yes. They can and they do. This may change, however. The government, like the proverbial fly on the wall, invades the sanctity of our bedrooms and governs the very acts of intimacy that we all believe are most private and holy. Title 18, Chapter 66 of the Idaho Code makes illegal a series of actions, some of which even I would not argue against. We understand the reason for preventing incest and forcible violations of the body, but do we understand the need in today's world for making criminal, yes, I say criminal, what occurs with regularity in our society? For example, the cohabitation of two individuals as man and wife without benefit of clergy is criminal in Idaho. I am not denigrating marriage, especially when my own is as successful as it is, but I do recognize that materially large portions of the adults in this very community live in loving, long-term relationships, but who have not yet procured a marriage license. It is also true that it is criminal, yes, criminal, for persons who are in the process of a divorce to have intimate relationships with another prior to the final dissolution of divorce being granted by a magistrate. And what's more, it's criminal for those same two persons to do those same acts even after the magistrate dissolves the bonds of matrimony. More interesting, however, is that in Idaho, we still have a statutory enactment, as do many of our sister states. And it's bizarre in its crafting. It has been that way for many years and probably will not change. And it is the only criminal statute of which I am aware after 27 years of practice, which does not define within its four corners the criminal acts. I quote to you the statute in its entirety. Every person who is guilty of the infamous crime against nature, committed with mankind or with any animal, is punishable by imprisonment in the state prison of not less than 5 years. That is the criminal enactment. What does it mean? I cannot tell you what it means from what it says, but the courts have told us everybody knows what it means. Leaving bestiality out of this debate, we are left to wonder to what it refers. Does it not perhaps appeal more to our prurient interest, simply the way it's written? I don't know. I suggest to you that the courts of this and other jurisdictions have found that this scant definition makes criminal certain acts between men and men, between women and women, and yes, between men and women, married or single, matters not. Even when those parties willingly and consensually engage in those acts in the privacy of their own home. There are some enlightened states that have determined that sodomy laws are constitutionally infirm. The New York Court of Appeals has so ruled, and have stricken them from their books. I dare not ask any of you for the standards you apply in your own bedroom, but rhetorically I ask, how many of you are criminals? It's important to recognize that this statute does not exist and make criminal simply acts which are forcible and violent of compulsion. The statute makes criminal what is both loving and gentle. I would agree that the definition of family as existing at the turn of this century is somewhat changed in today's world. Families in the main no longer require large numbers of children solely and exclusively to help with farm chores. But in point of fact, families no longer necessarily have that duration of till death do us part. And in point of fact, more children in this country are raised in single-family homes than raised in the homes to which they were born. Our body of law continues to exist and grants to us special rights by virtue of marriage, from property rights to taxes to torts. There is an advantage to legal coverture, but why should the law permit the creation, or rather not permit the creation, of parallel benefits to those who are loving life partners who enter such an agreement by contract or with judicial decree? Or is it rather that society wishes to punish people because of the particular class in which they find themselves? The classes being married, single, or other. Other perhaps being the infamously criminal. Do we have a right to sexual gratification? And should that right be protected as jealously as the right of free speech? I suggest that the principles of equal protection of the laws apply to a loving man and woman who choose to live together without a marriage license, and the same to two men or to two women. I suggest to you this, as have other writers, that extending sexual liberty to the unmarried is as surely founded in equal protection as any other of our constitutional protections, and that decisions regarding private sexual intimacy, marital status notwithstanding, are private and should not be addressed by the law. Unfortunately, the courts and the legislatures have not come to grips with this concept. Though I am perhaps today preaching to the choir, I put it to you that love and sexual gratification can and do exist outside marriage, and surprisingly, sometimes they do not exist in marriage. This, however, is not the issue. The point is that the state has undertaken to sponsor one institution that has as its core the love-sex relationship. That relationship demands liberty in the practice of sexual acts. Historically, nations in the main have confined sexuality to lawful marriage, Margaret Mead and coming of age in Samoa to the contrary. That principle is bottomed essentially on a procreative aspect of marriage and the government's interest in having an adult legally responsible for an incompetent child. It ignores, however, the other aspects of intimate human life and must be given credence because, as modern society has come to realize, the purpose of sex in the human species is not procreation. I am sure that from a statistical point of view, the chances of conception during any particular 28-day cycle is low in any event, and with the availability of contraception reduced even further. The relatively small risk of conception in the human species has been reduced, at least in our society, even further by the commonly available birth control procedures that are now distributed in the grammar schools and the junior high schools in this country. That is done, of course, because of need. We are becoming closer to reality. I submit to you that it remains for the courts and the legislatures to recognize this fact and give effect to the societal norms and expectation that inform our world today. There are those who say that if we countenance unmarried persons being the equal of married people, that a whole new area of spousal benefits for unmarried partners will be addressed. And perhaps that's so. I submit to you that it will not be a problem that cannot be addressed, for it is comfortably being addressed by many corporate employers today and many municipal and county governments. It has been argued that there should be a constitutional right which would give any intimate association between two persons the same protection as the law now gives to relationships based on marriage and kinship. It is interesting to note that the New York Court of Appeals has constitutionally extended the right of privacy, to protect the rights of unmarried adults to seek sexual gratification. They have, in fact, opened their eyes to the modern world. This is not to be confused with the circumstances which exist in a child custody matter where the court has certainly preserved the right to intervene in the best interest of a child. That argument is beyond cavil. Contemporary legal writers take for granted that the right to marry is grounded in respect for freedom of choice in intimate personal relationships, since choice of domestic companionship constitutes the kind of intimate personal decision that is the heart of the court's evolving privacy doctrines. Historically, the courts viewed marriage cases as turning on the importance of marriage to society. In the more recent view, the courts have now turned on the relationship of the marriage to the individual. Ideas about individual rights derive from the original theory of the Constitution, which deals with the relationship between the individuals and the state. I submit to you that private conduct is part of due process liberty. Modern courts now focus on what they view as the lack of the state's interest in preventing private behavior rather than in the nature of the behavior itself. Again, balancing the individual's rights and society's interests. It is true that family life has been the major cornerstone and bedrock of society. Notwithstanding, societal norms in the Western world are changing, and to that extent that marriage as we once knew it is no more, and it is currently evolving further. Thus, issues of single-parent adoptions, gay family adoptions are now being viewed more liberally by courts across this nation. A child has a moral right and should have a legal right to receive parental love, affection, discipline, guidance, and to grow to maturity in a home environment which enables him to develop as a mature and responsible adult. This can happen in non-classical families, and oftentimes does not happen in more formalized families. To legally prevent children from being reared in homes that are non-classical is clearly flawed in the law. It is important to note that scientific journals are replete with documented studies that show that the sexuality of parents, that is gay or straight, does not impinge upon the sexuality of their children. Now as to the Idaho Citizens Alliance proposition. This is presently subject of great scrutiny. I share with you that the laws respecting the treatment of people based on their sexual orientation are being examined. This particular law, which is being proposed as a proposition, is being crafted in such a way to make it illegal for this state or any of its agencies to sanction homosexuality in any way or by giving homosexuality the protections of minority status under the Idaho State Constitution. It's cleverly crafted. You may think it sounds reasonable. Certainly, we do not normally think of homosexuality as being within the same class as other more typical minorities, such as race, color, religion. But I might point out that age and gender are also protected statuses under discrimination laws in this country. I am not sure about the number of aged in this country, but I am confident that females are not in the minority. So minority status is really a fluid concept designed to protect classes of people against whom discriminatory practices which disrupt the normal flow of social and economic transactions and which prohibit or impede individuals within those classes from obtaining equal treatment under the laws. The real point is that Idaho law does not explicitly protect persons of minority class, or women for that matter. It does, however, prohibit discrimination, and that is the base upon which this is built. So by saying that homosexuals shall not under Idaho law enjoy the advantage of being the legal or social equivalent of any other minority, the Idaho Citizens Alliance Initiative is actually saying that homosexuals cannot be treated equally under the law, since the law, by its operation of prohibition of discrimination, sometimes ends up protecting people who happen to have minority status. Whether you agree or not with that proposition, it is well crafted. The repercussions, if this act becomes law in Idaho, is such that it would prohibit gays, by example, of seeking relief in the court system of this state. I have never experienced the denial of the right of access to courts to any person at any time. And if you do not have sufficient monies to file a lawsuit, the court will waive that provision. The courts of this country are open to everyone. The law explicitly prohibits homosexuality from being addressed in public schools or in any private school which receives state funding. That means that we could not here in this auditorium on this day discuss a gay rights issue. We couldn't even debate the subject, nor could we perhaps discuss certain of the writings of Plato, Socrates, or some of the works of Michelangelo, for you do know they were gay. We couldn't hear K.D. Lang at the fairgrounds. There is no end to the kind of subtle discrimination which would occur if this were in fact passed. This initiative states that it shall not be construed to deny any citizens, based on perceived or actual private sexual practices, any government services, licenses, approvals, or otherwise. That means they could not restrict homosexual people to the extent that they cannot have driver's licenses. Now, I consider that to be a pretty fine advantage. It perhaps means that they may also be doctors, so long as they don't discuss any of that in their medical practice. I don't want to address the question of lawyers. I suggest to you all that you participate in opposing this particular proposition, for should it be passed, it will certainly fail in the courts. It may be a painful and a disruptive campaign, I know that, but it cannot possibly ever form a part of the law in this state. I urge that all of you participate in nipping it in the bud. Let's talk about some practical considerations of how this works in the real life. Privacy. Take, for example, garbage. You all have garbage. You take your garbage and you put it in a plastic bag and put it outside for the garbage man to pick up. What is your expectation? Clearly, that your neighbor will not come and look in your garbage bag to see what you've been drinking, to whom you've been writing, or even what you've been smoking. But today, we have cases lately pending in the Idaho Supreme Court to determine whether or not a law enforcement officer may, without benefit of warrant, pick up your garbage and examine it at the police station. When he does that, he looks into your life. Should that be allowed? Well, I tell you that the United States Supreme Court says yes. When you put the garbage out, you've abandoned it. Fortunately, Idaho guards privacy a little more dearly, and I suspect that they will rule in Idaho, and this is just one old country lawyer's opinion, that it may not be done without benefit of a search warrant. And that, my friends, is an issue of privacy. Let us talk a little bit about wiretaps. You understand, in order to get a wiretap, you must go to a judge. You must give him some reasoning that rises to a certain level. There is a protection. The judge you go to in Idaho is a magistrate. That is a lower court judge. And that magistrate will hear, without opposition, because you're not there to defend yourself, what a police officer says is a basis for that invasion. And if the judge, a detached magistrate, is convinced, he will grant the privilege and a wiretap will be put in place. I do not have a problem with that. In the main, that works well. But let me share with you how broad our state legislature has viewed the rights of privacy. Because we're not just a bunch of redneck old country folk here. We are concerned about personal privacy in Idaho. We have a statute here in Idaho that says, if you want, as a police officer, to get my telephone bill and see the numbers I've called, if you want to get my utility bill and to see if I've got some special lights out in the barn for some indoor growing operation of some kind, probably tomatoes, hydroponically grown. Did I say something funny? Or if the police want to see my bank account and look at my transactions, they must go to a district judge, not a magistrate, the next highest level of trial court judge, and ask the district judge for that privilege. And then, of course, give sufficient evidence to meet the statutory requirement. That suggests to me that our legislature is, in the main, concerned about privacy. There are many things that are private to us. Our bank accounts and our financial transactions are only one. I submit to you that Idaho, more than many states, is cognizant of the need for the protection of the rights of the individual, both constitutionally written and as interpreted, and that the legislature will stand behind us on this subject. And I ask also that the people of this state stand behind us on the subject of this proposed statutory enactment. Thank you. I don't know if anybody has any particular bone to pick, but you're here, and my car's probably already been towed. So if there's a question, I'll field it. If there is a question.
Yes, other than the law enforcement officers going through the garbage and looking for the marijuana cigarettes, which you mentioned earlier, what is the case that you're aware of that to you is the most pervasive invasion of privacy in Idaho?
God. I have to tell you that I'm hard-pressed to give you a fair answer to that. I really do think, however, that some time ago we had a circumstance which occurred on a portion of the interstate here in Idaho, namely the rest stop facility at Hutter. and I have some familiarity with the criminal aspects of that case. And for those of you who don't know, it had become well known among the truckers on the interstate that if you needed a little social relief, you could stop at Hutter. And the Idaho State Police decided that they would take an undercover officer. I don't know how he got picked. He must have been lucky. And he would spend hours on hours in a stall in the men's room at Hutter. I don't know whether he got paid overtime for it or not, but there should have been some sort of combat bonus. And he remained in the stall, and there was a small hole between the two stalls, and he would lean down and he would look through. And perhaps he should have been turned to a block of salt, I don't know. But they prosecuted a series of people because of those actions. Now, I suggest to you that if there are places where privacy surely exists, it is in a cubicle in a men's room, whether it be in a public place or a private place, because I do not fancy anybody watching me in there. Whatever act was solicited or asked for was, again, between two adults, as private as physically possible. The outside world couldn't see it. But they prosecuted people for it. They embarrassed people for it. Now, I personally don't indulge in sexual activity in public restrooms, but to each his own. And I cannot understand why any governmental authority, absent some violence that may have been going on as a result of this. If prostitutes are soliciting people and taking them to corners somewhere and beating them on their head and robbing them, that certainly deserves pursuing with zeal. But to pursue those people who sought gratification under those circumstances, to me, is obscene and not in the interest of society, for nobody benefited from it. So, if I sound angry, perhaps I am, because I think it was sinful. I think it was a waste of time, but there were people whose lives were ruined because of that. And it is very interesting about crimes of this nature. There is no defense in the eyes of the community to those who are charged with those crimes. Acquittal by a jury, unfortunately, is not an acquittal. So that any individual who may have seen the eyeball looking through and bent down while in a moment of personal act of call to nature, and who thereafter was charged, will never have that removed from his record, not only in the annals of the courtroom, but in the eyes of his friends and neighbors. Yes, perhaps that is the best example. There may be others, and I'm not all-knowing, but I'm interested in hearing of anybody else's, and perhaps the next time I give a lecture, if I'm invited again, I can discuss it. Next question.
I'm a student here at NIC, and I know all too well the feeling of demeaning and embarrassment. I was, when I was quite young, I was staying with a friend who had a search warrant at his house, and I was living there at the time, and I had all my personal belongings held up for inspection, and private underwear in the drawers and things, and it was very, I felt very small at that time, even though I had nothing to be ashamed of. Tell me what things are going on in Washington State. I'm a citizen of Washington State, and I wonder if you know possibly anything that might be going on there.
Well, relative to this proposition that is being proposed here in Idaho, there really is a three-pronged attack somehow everyone thinks all the kooks live in the Northwest. I don't know why that happens, but we have some, perhaps, myself included. But as I understand it, this group is proposing a parallel initiative in Oregon, Washington, and Idaho, thinking that they can blitz it and get it through. Let me make one comment, please. I did not intend, and I specifically deny, any possible implication that may be presumed from what I said, that all police are bad, that all search warrants are vile. Not at all. In point of fact, I regularly represent law enforcement personnel in a whole series of issues, just as well as defending criminal charges in our courts. It's a question of abuses, and abuses occur. There are good cops, there are bad cops, there are good lawyers and bad lawyers, good teachers and bad teachers. But nonetheless, I am not suggesting that the whole system is foul. It's not. It's the abuses that we focus on, and it's the abuses we should try to address. Anything further? Sir, if you would use the microphone. Yes, ma'am.
I just have, I'm real curious to find out where you stand on mandatory drug testing, where
Well,
you've got individual rights and at the same time you have the rights of coworkers, and at the same time they are, it goes into invasion of privacy of what you do in your home.
I can respond to that, and I can give you only my opinion. And that is that, and by the way, I'm not happy with my opinion. I wish it weren't my opinion. But I do believe that an employer can, and the courts agree, impose restrictions on its employees to suggest that if you are doing certain illegal acts off duty, that it may impinge upon the circumstances at work. And I think that unfortunately, even though certain things we do at home are not brought to the workplace, that there is a perception that it is, and sometimes it is, and that employers can therefore do drug testing for its employees and make that drug testing mandatory. And we have to have some sympathy for the flip side, and that is that if you were working on the green chain down at LP, you would want to have all your wits about you. I wouldn't want you high on grass. I wouldn't want you high on alcohol as your employer. And I think that the paternalistic attitude pervades, and those drug testing provisions are lawful right now.
Can you tell me your opinion on the Randy Weaver and the Waco, Texas invasion of privacy?
Sure I can. Do we have about 3 hours? Shall this be the last question?
One or two more.
Okay, 1 or 2 more. I'll respond to you this way. First of all, when Johnny Carson used to come out at night with that bizarre hat and divine the answers to the questions in the envelope sealed in the mayonnaise jar on Funk and Wagnall's back porch, I'm going to do a little predicting too. I'm going to predict that in the Randy Weaver matter, in the main, he will be acquitted. I think that unfortunately there has been, and I'm going to leave the Idaho State Police out of this because it was not their case, there has been some serious mismanagement in the U.S. Marshal Service and in some of the federal police agencies that have no business wearing guns. I have experienced in my years in the practice of criminal law a fair amount of shootings and a fair amount of violence. I have never seen a bigger screw up in my life than has occurred in both of those circumstances. Are you aware that in the Weaver matter, the man was charged with a misdemeanor? Not a felony, a misdemeanor. He had, and I'm not defending him, by the way, he was marching to a different drummer. But he lived out where he could play his music as loud as he damn well pleased. But he had a shotgun that was about a half-inch too short. A crime. No defense. A crime, a criminal act. He can go to jail. But it was a misdemeanor. The lowest of crimes. Overreaction, bad management, lack of planning, inept personnel, lack of training, created what I see as a tragedy. And since, and I said it twice in my speech to you, those who do not study history are forced to relive it. It happened again in Waco, Texas. If you examine what those poor benighted U.S. Marshals went through, you saw that they put themselves in harm's way and they suffered. I do not wish them ill. They're good men and women. But God, they were dumb. Hearing no more, I'll take my leave. Thank you very much.
I'd like to thank Harvey Richman for being here this morning and remind you to please come to the response panel to this presentation at noon in the Bonner Room of the Student Union Building. That will last an hour and a half. Thank you, and tomorrow's agenda will be the same time in this, no, at 11.